Students, in this lecture number 2, I am going to discuss with you the meaning and definition of the term contract. That what is the meaning of the contract? The meaning of the contract can be made clear by the definition of the contract which has been given in section 2 clause H of the Act. According to section 2 clause H of the Act, it says that an agreement enforceable by law is a contract. I want to repeat, an agreement which is enforceable by law is a contract. That means to say, to constitute a contract, there must be two things. First of all, there must be an agreement, okay, and that agreement should be enforceable by law. If there is no agreement, there will be no contract. And if there is an agreement, but it is not enforceable by law, then it will not become the contract. So, to fulfill both the condition, there must be an agreement and that agreement should be enforceable by law. And what is the meaning of agreement? Section 2 clause E defines agreement as every promise and every set of promises forming consideration for each other is called agreement. So, in an agreement, there may be one promise and there may be more than one promises which are forming consideration for each other is called agreement. Consideration means something in return. And what is the meaning of promise? Promise has been defined in section 2 clause B. According to section 2 clause B of the Act, a proposal becomes a promise. A proposal becomes a promise when it is accepted by a person to whom it is made. So it is very important to see here. One person signifies that he want to do this. He makes the proposal to the other person. That proposal must be accepted by the person to whom the proposal is made. If it is not accepted by the person to whom the proposal is made, it will not become the promise. So, the proposal must be accepted by the person to whom the proposal was given or on his behalf by any person, provided that person must be authorized by the person to whom the proposal is given. For example, if A gives any offer to B, that offer / proposal must be accepted by B alone. Apart from B, any other person cannot accept that proposal. So, proposal becomes a promise when it is accepted by a person to whom it is made. And an agreement requires mutual understanding between the parties. There must be mutual understanding between the parties. That means to say, there must be a meeting of minds of both the parties to the agreement. They must agree on the same thing in the same sense so that agreement can be formed. If they are not agree on the same thing in the same sense, then there will be no formation of an agreement. And this is called consensus ad idem. That means to say, when two persons agree on the same thing in the same sense, it is called consensus ad idem. Therefore, we can conclude that agreement is equal to offer plus acceptance. Offer must be accepted by the person to whom it is made. Okay? Now the agreement has been formed. And thereafter, agreement must be enforceable by law. That means to say there must be the intention of both the parties to the agreement to create the legal obligation against each other. Unless and until there was not any such intention to create legal relationship between the parties, it will not be enforceable by law. If it will not be enforceable by law, it will not become the contract. So what is written in the notes? The agreement must be enforceable by law. That means that agreement must create the legal obligations on the part of the parties. Therefore, if the parties to the agreement do not intend to create legal obligations for each other, then a contract does not comes into existence. Therefore, it can be concluded that contract is equal to agreement plus enforceability by law. That means to say an agreement enforceable by law is a contract. Now this point of enforceability by law can be made clear by these two examples. Let us take first example. A invites his friend B to a dinner in his house. Okay. A invite his friend B to a dinner in his house. B was very happy that I will take my dinner today in the night in the house of A. B, in the happiness, hires a taxi and reaches A's house at the appointed time. But what has happened in the house of A? But A fails to perform his promise. Now, in this case, B cannot claim any compensation from A by filing any civil suit in the court of law, because the agreement between A and B is of a social nature. There was not any intention either of A or of B to create any legal obligations with each other. Since this agreement is not enforceable at law, this was the agreement, but as it is not enforceable at law, hence it cannot be regarded as a contract. Now let us take an example, another B example. A offers to sell his bike to B for Rs 30,000. A is saying that I want to sell this bike to B for Rs 30,000. B accept the offer of A. This is an agreement because in this case both A and B wants to create legal obligations with each other. And this is an agreement which is enforceable by law, so it is a contract. That means an agreement which is enforceable by law. So if thereafter either A or B breach their contract, they will be liable for that. Thus, from all the discussions, it has been made clear that the scope of an agreement is wider in comparison to the contract, because in agreement it contains social as well as legal agreements. In agreement, social as well as legal agreements are included, whereas only those agreements which are enforceable by law can be regarded as contract. So it indicates that all the agreements are not contracts, but all the contracts are agreements. So this is something about this lecture today. In the next lecture, we will discuss how the agreement becomes the contract, and the elements of the contract we will discuss in the next lecture. Section number 10 governs that. Thank you very much.